It's been 6 years since the financial crisis, and there are a lot of people who wonder, why has no bank been brought up on any criminal charges? Well, indicting a bank is a tricky thing. If the government was to label a major financial institution a criminal enterprise, there could then be a run on that bank, causing far greater damage to the economy than whatever malfeasance was conducted by that bank. So, what's a federal prosecutor to do? So far, government lawyers have avoided this doomsday scenario by brokering settlements called deferred prosecution agreements. In 2012, the U.S. Department of Justice accused bank HSBC of stunning failures related to money laundering. But instead of going to court, HSBC admitted to the violations and agreed to forfeit $1.3 billion. Today, two big banks are under the federal microscope. Swiss banking giant Credit Suisse is facing indictment over helping Americans evade taxes. France's largest bank, BNP Paribas, has been investigated for processing transactions from blacklisted companies in countries like Sudan, Cuba, and Iran. There haven't been any criminal indictments yet, but that doesn't mean there won't be.
To be clear, no individual or company, no matter how large or how profitable, is above the law.
The prevailing argument, particularly in the financial community, is that any criminal prosecution could result in a bank losing its charter, which could then set off a panic in the market and cause general financial havoc. The U.S. Attorney for the Southern District of New York, Preet Bharara, thinks that argument is just a scare tactic, calling it a gaping liability loophole that blameworthy companies are only too willing to exploit. The question is whether it's just that, or if banks that are too big to fail are, in fact, too big to jail.